One of the biggest themes in management rights over the last couple of years has been the separation of the real estate from the business component. Certainly we're seeing lots more business onlys sold off the plan, and we're seeing lots of clients come back to us to ask to separate that obligation to own or reside from their management rights agreements. So from an industry perspective, it's a tiny bit concerning because in one sense that takes away from the strength of the management rights model where you're actually living on site. But the reality is that in an environment where interest rates are higher, residential real estate is higher in terms of price, having an expensive unit with a smaller net profit does make it harder to sell or finance your business. So we're seeing a lot of this. So when we're approached by a client to deal with this, the first question I always ask them is your committee on the bus? Because if the committee doesn't understand why it is that you're doing or what you're trying to achieve and lobbies against it, it's almost certain that this type of variation will be defeated. So the starting point is to make sure the committee understands what it is that you're doing. And even if they're not necessarily supportive of it, maybe they're apathetic. That's also okay. But a committee lobbying against this type of proposal is usually death to it. So you don't want to go there. Once you get the knowledge that you're likely to be successful if you ask the body corporate to do what needs to be done, we need to go through the legal process. So the first thing is, what do the bylaws say? So the bylaws might provide, or usually will provide, for protection for a lot to be used for management and letting purposes. We need to deal with that, because if you're not going to have a specific lot, then we need to take that out of the bylaws. And that requires a special resolution. So that is 66% of those who voting in favour, and effectively no more than 25% of the lots against. The next thing is to look at the management rights agreements. We need to see what the obligations are in there about ownership and residence, because you can also change these around to perhaps still have the obligation to reside but not own, or the obligation to own and not reside, or no obligation at all to own or reside. So that's part of the process we need to go through. So you might look at, or we will look at the provisions relating to termination, relating to assignment, and the duties in relation to occupancy or ownership, because those need to be addressed. Changing management rights agreements is an ordinary resolution, which is simply more votes for than against of those who choose to vote. And then it's a question of putting both of those things to the general meeting and letting owners know what it is that you're trying to do. So if you engage us to do that, we'll give you a helpful sort of Q&A in terms of the common questions that get asked by owners and how you're likely to respond. So that's the process. But again, this is one of those ones where you want to make sure that there's a bit of engagement with your committee before you start, because there's no point wasting money if they're going to be against it. But if you need help on this, just let us know.